Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, everyone. My name is Rasa Fumagalli. I'm an attorney licensed in Illinois, and I'm the Director of Medicare Secondary Payer Compliance here at Synergy Settlement Services. I'd like to welcome you today to our third Thursday of the month webinar. Today, we're going to be looking at the current state of proposed rulemaking in regard to liability Medicare set-asides. We are also going to take a look at the Medicare Secondary Payer Act, a look at CMS's agency actions, some cases, and go over ways that you might want to consider when it comes to addressing Medicare's potential interest in your client's settlement. I will also be looking at conditional payments with you. At the end of the presentation, we will have 10 to 15 minutes set aside to answer some questions. For those of you who may be new to Synergy Settlement Services, we offer a comprehensive suite of services that can help you address all of your Medicare secondary payer compliance issues. We have an initial consultation with our Medicare expert case evaluation. We can assist with the preparation of allocations, life care plans, perform reviews of opponents' Medicare set-aside recommendations. We assist in the resolution of liens, with administration and structured funding. Other services are also available. At the last time that we had a webinar on MSP compliance issues was this past July. At that time, we were all waiting for CMS to provide more information regarding the notice of proposed rulemaking. And although the second CMS attempt started out with a notice in 2018, the date of this has been pushed out on several occasions. The last date that was out there for this notice of proposed rulemaking was in August of 2020. Of course, here it is November and nothing has actually taken place. We only have the same abstract of the proposed rule. So if you look at the language of the proposed rule, though, it seeks to clarify existing MSP obligations in regard to future medical items, services that are related to liability settlements, judgments, awards, or other payments. The language also references no fault and workers' comp, although we are not going to address those areas during this presentation. What the language of the proposed rule states is that this is going to be something that is on the Medicare beneficiary that has to be addressed when it comes to satisfying Medicare's interest in regard to future medical. Now, ever since the notice of proposed rulemaking came out in late 2018, people have been trying to get more information about what this actually means, what the proposed rule would look like, and what sort of process would be in place for a liability MSA. In the fall of 2019, the Medicare Secondary Payer Network, formerly NAMSAP, had representatives, and there were several other groups that are very active in the MSP compliance space, meet with CMS in order to provide their input on what the process should look like. The group meetings highlighted the fact that the CMS process for a liability MSA cannot look the same way that it does for a workers' comp MSA. There are significant differences between the two types of cases. Workers' comp cases don't have to concern themselves with policy limits. You also don't have all of these other liability issues in a workers' comp case that comes up in the same way that they do for personal injury settlements. The takeaway from these meetings, even though CMS was not able to make a formal statement, makes it clear that CMS does intend to go forward with issuing rules that are going to address liability settlements. It's also clear that eventually there will be a review process, but the most important thing is that the burden of compliance for future medical is going to be on the plaintiff. The enforcement mechanism is going for failure to address Medicare's interest in the settlement is going to be the denial of services. So what does this mean when it comes to actually handling a claim when you have a personal injury case involving a Medicare beneficiary that is going to require future injury-related care? Although the notice of proposed rulemaking is in a holding pattern, MSP compliance does not stem from any sort of rule. It actually stems from the Medicare Secondary Payer Act. If your client is a Medicare beneficiary at time of settlement, there really should be a discussion of the MSP Act so that your client can make an informed decision about the best way that they want to proceed in their case. The approach is going to be unique to the facts of the case. You're going to be looking at the need for future care, the nature of the settlement agreement, and your client's risk tolerance. You can sort of think of the MSP Act as a speed limit on the highway. The speed limit is there. It may or may not be enforced by the police, but you know that it exists. A decision to speed or not speed is going to be an informed decision, and it's going to be based on your risk tolerance. If you know that a particular area is a speed trap, you may choose to slow down, or if you are in a rush, you may go for it and risk the ticket. The point is that you as the driver are making an informed decision. When it comes to potential issues with Medicare, your clients should be making informed decisions. So let's take a look at the Medicare Secondary Payer Act itself. The Act clearly states that Medicare is a secondary payer when payment has been made or can reasonably be expected to be made by, under a workers' comp law or plan of the United States or a state, or under an automobile or liability insurance policy or plan, or under no-fault insurance. Although Medicare is a secondary payer, they can pay for injury-related expenses prior to settlement when payment is not expected to be made within 120 days of receipt of the claim by the primary payer. And this type of payment is a conditional payment, and it is one that has to be reimbursed to the Medicare Trust Fund. So whenever you're going to be settling a claim and Medicare has made a payment, you have to be mindful that this has to be addressed. Whether it is going to be reimbursed to Medicare or it's going to be disputed and negotiated is a different story. You just cannot ignore this conditional payment. 42 CFR section 411.20 talks about Medicare exclusions from making payment. Medicare is precluded from making payment for services when payment has been made under a liability insurance plan. Primary payer's reimbursement obligation to Medicare can be demonstrated by a judgment, a payment conditioned upon the recipient's compromise, waiver, or release, whether or not there's a determination or admission of liability, of payment for items included in a claim against the primary payer, or by other means. The second part of this 42 CFR section 411.22 is important in that it clearly states that there's this reimbursement obligation whether or not people are accepting liability for the claim. You also really want to be very careful when it comes to conditions that are included in the claim, since Medicare is going to view itself as a secondary payer if payment is made for a specific condition. What this means is that if you thought you could prove up 10 injuries in your case, but really the focus of the treatment and damages only involve 3 injuries, it's much better to identify the 3 injuries as the conditions that are being compensated in the settlement. Now, when you think about obligations under the MSP Act, you should keep in mind that there are three distinct parts to it. There is the conditional payment reimbursement obligation, which addresses past payments made prior to settlement. There is the need to avoid a cost shift of future injury-related expenses to Medicare at time of settlement. And then there is the Section 111 mandatory insurer reporting requirement, which is placed on the defendant's primary payers in the case. The Section 111 total payment obligation to claimant report puts Medicare on notice of a settlement involving a Medicare beneficiary, the amount of the settlement, and the diagnosis codes and conditions that are being released in connection with the settlement. So we just reviewed the law and existing regulations. So let's take a look at what CMS has been doing when it comes to liability cases. Right. Over the years, there have been a few guidance memos. They also rolled out Section 111 reporting. The May 2011 CMS Stalkup memo clearly states that there's no distinction between workers' compensation and liability cases when it comes to the obligation to protect the Medicare Trust Fund from paying for future medical services. CMS's preferred method is a Medicare set-aside recommendation. The next significant CMS memo came out in September of 2011. This memo states that when you have a written treating physician certification that the injury-related treatment has concluded by the time of settlement and that no future care will be needed, no liability MSA is needed. Now, this option is a good option to pursue, but you also have to watch to make sure that this treating physician's certification is credible. If you have medical records that show that the treating physician 2 weeks earlier was discussing extensive ongoing injury-related treatment, this drastic change in position is going to be suspect. In 2013 and 2014, CMS took a stab at the notice of proposed rulemaking in liability cases, but they withdrew the notice. As you can see from the slide, the total payment obligation to claimant reporting threshold for liability cases has steadily decreased over time. While in 2011, liability plans had to report TPOCs that were $100,000, as of 2017, any physical trauma settlement over $750 has to be reported. There is no limit whatsoever for other cases in terms of the reporting threshold. In 2016, CMS began looking for a new workers' compensation review contractor. It's important to know that they also wanted the contractor to be able to review liability MSAs. In December of 2018, OMB published Notice of Proposed Rulemaking for Liability Settlements. And these are the rules that we discussed earlier on in the presentation. Given the lack of specific regulations that address Medicare's interest in liability settlements when it comes to future medicals, parties are dealing with this issue on their own. We have a few cases where courts have looked at equitable apportionment of funds for future medical and compromise settlements. We have the Orenke case that states that no federal law or CMS regulation requires the creation of an MSA in liability cases. It's also important to note that there is no requirement to create an MSA in a workers' comp case either. MSP compliance obligations stem from the Medicare Secondary Payer Act. Now that we've reviewed the legal landscape for MSP compliance and took a look at what CMS has been up to, when you are meeting with clients, it's a good idea to determine whether they are Medicare eligible upfront. This should be part of your regular intake process. You can become eligible for Medicare provided you have sufficient working credits when you turn 65 or if you have been receiving Social Security disability benefits for 24 months. There are also certain diseases that will qualify you for Medicare coverage as well. There is end-stage renal disease as well as Lou Gehrig's disease. Disabled children may also qualify under their parents' coverage at times. Once you've determined that your client is on Medicare, it's important to discuss Medicare's potential interest in the settlement. You want to protect your client and your firm while considering Medicare's interest in the settlement. If you don't, you might encounter the following situation. Take a look at this case where a plaintiff accepted an $80,000 settlement for a shoulder injury. There was no consideration of Medicare's interest in the settlement. Section 111 reporting took place, and Medicare is notified of the settlement and the nature of the injury. Medicare then denies payment of right shoulder treatment, and the petitioner's attorney is threatened with a legal malpractice action. This is what a Medicare denial of service will look like. As you can see in the highlighted section, the letter states, your claim has been denied by Medicare because you may have funds set aside from your settlement to pay for your future medical expenses and prescription drug treatment related to your injury. This does happen. It doesn't always happen, but this possibility should be discussed with your Medicare beneficiary client. You should let them know that this Medicare Secondary Payer Act speed limit exists. There are several different approaches that you could take in order to protect your client while considering Medicare's interest in the settlement. Oftentimes, you may have defendants pushing for a fully funded MSA that is going to come out of their settlement offer. Other times, you may have a push to get the treating physician certification that no future care is needed. Although this is a reasonable option under certain circumstances, when the defense is pushing it on you, it's likely going to be used as a basis to reduce the offer they're going to make. Timing of this is very important. Lastly, you may also see the defense attorney wanting to put language in the settlement terms that state that the plaintiff won't bill Medicare. So CMS actually considered this approach in its April 22, 2003 guidance memo that covered workers' comp settlements. It specifically rejected it, and there's no reason to believe that this provision would ever be enforceable or acceptable to Medicare. Liability cases have different considerations than workers' compensation cases. Liability cases have caps on damages, policy limits, and different liability issues than those faced in a workers' compensation claim. The approach of fully funding all future injury-related treatment can be problematic in a liability settlement when it's capped by policy limits. In this situation, the entire settlement might be eaten up by the future injury-related treatment expenses. There'd be nothing left to compensate for economic damages, pain and suffering, and fees. When the settlement does not fund future medical, when it is taken up by economic damages, fees, and pain and suffering, there is no cost shift of injury-related expenses to Medicare. Another method that may be considered involves an apportionment of the Medicare set aside. This approach would look at the total potential case value and determine the ratio between it and the settlement amount. This percentage would then be applied to the full MSA, and this figure would be carved out of the net settlement for future medical. I do have to caution that the approach that you take and the risk associated with a particular approach should be discussed, it should be assessed, and it should be properly documented. When you are representing a plaintiff, your end goal is going to be to avoid a cost shift of future injury-related medical expenses to Medicare. Depending on the facts of the case, this may be done through no MSA or by funding the lowest defensible MSA. There are other ways to pay for post-injury Medicare covered treatment without pushing the burden onto Medicare. There may be other health insurance. You can pay out of pocket. Your client may be able to set up a medical savings account in certain cases. A settlement preservation trust may be an option, or they may choose to purchase a structured settlement that is used for future medical care. All of these options are available and will prevent a cost shift of injury-related expenses to Medicare. When it comes to protecting a plaintiff's interest in a settlement while considering Medicare's interests, you need to ask a few questions. The first is you need to consider whether the plaintiff is actually eligible for Medicare benefits. The next question would be whether there is a need for future injury-related care that is covered by Medicare. And thirdly, you're going to look to see whether the settlement actually funds future medical care. Since the area of Medicare secondary payer compliance is specialized, you may want to consult with experts, advise your client of Medicare secondary payer implications, and most importantly, document the file. Issues that may come up when you are settling a claim with a Medicare beneficiary may include disagreements with your opponent on whether or not a liability MSA is appropriate, the amount of the LMSA, especially if it's going to be funded by the defense in addition to the settlement offer. You also have to be very careful about the diagnosis codes that are going to be reported under Section 111. For example, if the settlement involves a right knee injury. The Section 111 report should have a diagnosis code that is limited to the right knee instead of an overly broad diagnosis code that pertains to a right leg injury. If you have a reasonable relationship with your opponent, you should try to coordinate the codes which are going to be reported. If you don't really have such a great relationship, I would suggest that you actually document in a correspondence to your opponent what condition is actually being released in the claim and the accompanying diagnosis code. You also have to be careful to watch for overly broad settlement language. As we discussed earlier in the webinar, you do not necessarily want to have 10 conditions released when really the settlement of the claim involves 3 conditions. As I mentioned before, there is no one-size-fits-all MSP compliance recommendation when it comes to future medicals in a settlement involving a Medicare beneficiary. Our Medicare Expert Case Evaluation, or MECE consult, will help you address these issues with your client. The consult will result in either a no MSA letter, and the reasons for the no MSA letter will be outlined. There will be a recommendation for an MSA analysis with a possible apportionment, or if your client declines to take any action, the MECE consult would end with a prepared waiver and acknowledgement that the plaintiff has been counseled on potential MSP compliance issues down the road, and they accept whatever risk may be associated with their inaction. Let's turn to now conditional payments. Conditional payment reimbursement obligations have to be taken seriously. Medicare is able to recover from a ton of people that are identified in the regs. They can pursue recovery from a primary payer, a beneficiary, a provider, supplier, physician, attorney, state agency, a private insurer that has received a primary payment. And the one that is probably most frightening for plaintiffs' attorneys is the fact that they are listed in here as one of the parties that may be pursued. An important consideration when we're talking about traditional Medicare Part A and Part B payments is that during the life of a claim, your client may actually be enrolled in many different types of plans. If you've had the case for several years, they may be enrolled in a traditional Medicare Part A and Part B plan early on in the claim. They may then enroll in a Medicare Advantage plan or a Medicare Part C plan. If the case lingers, they may then decide to flip back to traditional Medicare Part A and Part B. So it's really important that when you are evaluating your case, that you are mindful of the fact that there are these different types of Medicare plans that may play a role in your client's case. So if you have a person who is enrolled in traditional Medicare Part A and Part B, you are going to be able to obtain information about any payments that were made through the Medicare Secondary Payer Recovery Portal. And the way that all of this actually works is that your client, when they enroll in Medicare, they agree to advise Medicare when their need for treatment is due to the result, or is because of the action of a third party. And so they would have to report the case to the BCRC. The BCRC is going to issue this reminder letter, a rights and responsibility letter, which essentially lets the beneficiary know that when they settle their case, they're going to have to address conditional payments, and they have to let Medicare know about the settlement. When Medicare issues a conditional payment letter and it's before the case is fully settled, the information in that conditional payment letter is interim conditional payment information. That means that it's subject to change. So if you receive a conditional payment letter and it does include a payment summary form, or you receive this information via the portal, you are able to dispute unrelated charges. For a period of time, Medicare was pulling all sorts of unrelated diagnosis codes and trying to stick them onto particular claims. It was a problem that they had with their grouper error. So you could actually see a conditional payment claim that involved a low back injury, yet Medicare was seeking reimbursement for treatment provided in connection with a dog bite. So the payments that are identified in conditional payment letters really do have to be carefully scrutinized. So you can dispute the unrelated charges at various points in the settlement process. Once you give notice of the settlement to Medicare, Medicare and the BCRC, they're going to issue a final conditional payment demand, which is something that has to be addressed. Far too often, though, people don't really realize that the Section 111 Total Payment Obligation to Claimant report by the defense is also going to initiate and trigger the final conditional payment figure. So that is an obligation that the defendant has to comply with. So you cannot rely on an interim conditional payment letter and then be surprised when a different number pops up in response to the Section 111 TPOC report. It's important to understand the process so that you can negotiate and react accordingly. So once you receive a conditional payment demand, you have 60 days to do something before interest accrues. And appealing or seeking a waiver is not going to stop interest from running. So oftentimes many people actually pay the demand, then they work to seek a waiver or a compromise or a different resolution. In certain situations, Synergy has requested a waiver and we have received full refunds of the demand payments that were made in order to prevent interest from running. It's important to know that, if there's a discrepancy in the date of accident, for example, that's reported under Section 111, that may actually result in a brand new case being opened. So it is vital that people make sure that everybody is on the same page when it comes to the appropriate date of accident. As I mentioned earlier, it's also important that there is an agreement as to the Section 111 diagnosis codes that are going to be reported in a claim. When you have a claimant who is no longer enrolled in traditional Medicare Part A or Part B, they may be enrolled in a Medicare Part C or Part D plan. These are Medicare Advantage plans. The Medicare Part C plan is going to provide coverage for all of the services included under Part A and Part B. They will likely include additional services such as vision benefits, dental benefits. Medicare Part D plans traditionally provide prescription drug coverage. So the Medicare Advantage plans are administered by private insurance companies and they are paid a fixed amount each month by Medicare. Medicare Part A and Part B, on the other hand, payments are made to providers based on there's a fee that is paid per service. The Medicare Part C and Part D plans, even though they're administered by private insurance companies, they do have the right to recover under the Medicare Secondary Payer Act. So they can pursue reimbursement from all of the entities that a traditional Medicare Part A and Part B recovery action might involve. You cannot, however, obtain information regarding the payments that the Medicare Part C or Part D plan may have made through the Medicare Secondary Payer Recovery Portal. So it is imperative that you identify what Medicare Advantage plans your client may have been enrolled in since the date of the accident up until the time of settlement. If they do not have their insurance cards, you can possibly get information on this by looking at the medical bills that are being generated in the claim. They should theoretically show which plans are being billed. There should also be a reflection of what payments, if any, have been made. Your client should have access to information regarding the plans through mymedicare.gov, which is a website that they can register on, and they should be able to pull up their Medicare account. So more and more people are actually enrolling in the Medicare Advantage plans because of the fact that you do get this more expanded coverage. So the Medicare Secondary Payer Act is being used to pursue recovery under the double damages private cause of action provisions. And this has been accepted by Medicare, and 42 CFR 422108 specifically extends the private cause of action to the Medicare Advantage plan. There are several cases that have come out in terms of whether or not the Medicare Advantage plans actually have the right to seek recovery under the private cause of action. The first one that found the plan did was the In Re Avandia claim in the Third Circuit. Another case that is significant is the Humana Medical Plan versus Western Heritage case. In this situation, Humana was able to recover double their lien amount against Western Heritage, even though Western Heritage had already included the amount of the Humana payment in the settlement agreement with the plaintiff. So, you have to be mindful of this and investigate not only traditional Medicare Part A and Part B payments, but you also have to look for Part C, Part D payments. The Department of Justice is actually pursuing law firms for unpaid Medicare debts. And the amount of the Medicare debts aren't even staggering or anything. So I have included a list of the different Department of Justice actions that have been pursuing law firms. You can see in June of 2018, there was a settlement with a Philadelphia law firm. We had one in March of 2019, November, January 2020, and August of 2020. And because conditional payments can really result in significant issues for your firm, it's important that you have an internal process that is set up to consider how these conditional payments are being handled in your cases. You should not rely on your brand new hire who may not really understand conditional payments to take care of all of these issues. The Department of Justice actions have recommended that these firms designate a specific individual who will be responsible for monitoring conditional payments and claims. They will follow up in securing information from Medicare in regard to conditional payments, and there will be a review and an audit of how these cases are being handled within the law firm. So, conditional payment resolution is very important in terms of making sure that you don't have any issues with double damages. You also want to make sure that there aren't any issues with any offsets of benefits. So the area of Medicare secondary payer compliance is a complicated area. And it is one that should not be overlooked just because it is complicated and because it is getting in the way of your settlement. Anytime you have any Medicare secondary payer compliance issues, please feel free to reach out to us at Synergy Settlement Services. I would be happy to assist you in helping with recommendations for your claim. At this time, we are going to stop and look for some questions. Thank you.
All right, so here is a question about the type of numbers that are being used in projecting a Medicare set aside. So the Medicare set aside projections in a liability case are not projected out at the Medicare fee schedule. And the reason that we do not use the Medicare fee schedule is because the agreement to accept the Medicare fee schedule rate is one which is entered into between the providers and Medicare. So your client would not actually have the right to demand that he or she be billed at the Medicare rate. The MSA is then going to be projected based on the usual and customary charges for the geographical zip code where the case is actually settling in. Once you have a Medicare set-aside account that is actually projected out in that way, then the payments that are going to be made from the account are going to be based on the usual and customary charges. Okay, let me see. Here's another question. Okay, so here's a question. Are you aware of any case where a treating physician declined to write the appropriate letter of no future related care because he realized the patient would have to pay his future bills at full charge rather than a Medicare paid reduction? And so this is described as a cynical question, which is an appropriate question. So, I personally do not have any knowledge where a treating physician really took the stance that, I would rather be paid out of an MSA at my full charges than bill Medicare for the services. I mean, usually there is a certain degree of, compassion that a treating physician is going to feel for his or her patient. What, as I mentioned, we would project the Medicare set-aside account out at usual and customary charges. If the physician refuses to accept a usual and customary rate payment from, the MSA, it can be fully paid from the MSA. But I think that they would still rather go ahead and bill Medicare if there were a need for future injury-related expenses. The point, though, is that you, as the treating physician, would really have to be of the mindset that this person has recovered from whatever injury-related condition they suffered. Thank you for that question. Here's another one that has to do with an individual who has both a workers' compensation case and a liability case from one accident. The question is, how do you handle the MSP compliance issues? In that particular case, the need to avoid future injury-related cost shifting to Medicare applies in both cases, but you're only going to have one future treatment projection, and whether it's funded from the workers' comp case or the liability case is really going to be up to the people that are involved in the settlement. So, for example, if you wanted to have CMS review of the settlement in the MSA, you would take care of the workers' comp MSA through that case, because that way you can seek submission of the proposal to CMS for review under workers' comp. Liability cases are not being reviewed, so that would be one way of addressing it. Okay, here's another question. How are specific diagnosis codes established? Where can you get them? So if you have a Medicare set-aside that is prepared, you would actually have the accepted diagnosis codes listed in the Medicare set-aside report. These diagnosis codes are identified in the medical records, and you can actually see electronic records, unfortunately, that sometimes pull primary diagnosis codes. They are also going to pull a ton of other codes. So you have to differentiate, make sure that the diagnosis code is the one that is the primary code that is being treated. How do you charge for your services? At what stage should counsel get Synergy involved? So the charge for the services depends on what service is requested. If you are seeking a Medicare case evaluation with your client with an opinion at the end of the consultation as to what the next course of action would be, that is a $1,000 MECE consult charge. In terms of what stage should counsel get Synergy involved, I mean, there are advantages to getting involved early in the case, in that if you do require some sort of a future treatment projection, our projections can help you negotiate your settlement. In terms of whether your actual settlement, though, is going to be significantly less than total potential case value, that future treatment assessment could actually be adjusted to take into account the fact that you're settling for far lower than the total potential case value. So there are many, different stages in the life of a claim where Synergy can assist. It is generally better to have a discussion about what your strategy is going to be when it comes to MSP compliance earlier in the case rather than later. Okay, so I will just wait a few more minutes to see if there are any other questions. Okay, let's see. Here's another one. The question is, at the time of settlement, will a written statement from the Medicare Advantage plan, such as Anthem, that state there are no liens at this time, satisfy MSP reporting requirements? Okay, so MSP reporting requirements under Section 111 are actually reporting requirements that the defendant and their responsible reporting entity have to take care of. So Section 111 reporting must be done when the case fully settles and you have a current Medicare beneficiary. If you are trying to figure out whether a Medicare Advantage plan actually has a lien, oftentimes what I've seen is that these plans will state there are no liens at this time, but let us know when you settle the case and we will do a final sweep. So I would caution that the Medicare Advantage plan may be giving you an interim figure, even though it's likely to be the same. There is a possibility that they may pull up some additional claims given the passage of time and treatment that might have occurred between the time when you obtain that written statement and the time that you're actually settling your claim. Okay, here is another question. My lawyer says there will be a global settlement. Does a global settlement in a PI case generally allocate a specific amount that is limited to past medical expenses as a result of the injury? I think that, the amount of the settlement that is going to be going for past medical expenses is really going to, depend on the facts in your particular claim. So if you have a global settlement that includes a workers' comp component to it, and there are disputed medical bills, they might actually be outlined in the case. I am not quite sure that I specifically answered the question that is being posed, but that is my best interpretation of this. Okay, let's see if there's anything else that's coming in. Okay, so here we go. The question is there an effective strategy for obtaining a reduction in the demand based on conditional payments where the injury involves a significant pre-existing pathology? And the answer is that yes, there are many ways that you can seek a reduction of conditional payments. We have found it helpful if we have medical documentation when we're doing a dispute to show that, the treatment for this pre-existing condition is something that has nothing to do with the accident. Therefore, Medicare, you really are the primary payer for it. There are also other ways in securing, reductions and disputes of conditional payments through, a waiver request once the case fully settles. You might be arguing that there's a financial hardship in the case. So you can definitely raise these arguments before Medicare in terms of reducing the conditional payments. Okay. Here's another one. We got a letter from CMS years after we settled a case where we were unaware that the person was on Medicare because PIP paid the medical treatment. What is the best way to handle this? Well, I think, one of the questions is, what is CMS saying? I mean, are they saying there are conditional payments? Are they looking for information about settlement? So I would caution that whatever letter you might be getting from CMS, chances are that it has some sort of timelines within it for action, and that it is far better off to take care of it immediately rather than putting it, aside and then not addressing it in a timely way. So I would recommend that, there be some sort of response or some sort of dialogue that takes place with CMS in regards to this particular question. Okay, so it does not look like we have any additional questions. Oh, yes, we do. Hold on a second here. Let's see what this is. What if the injury involves aggravation of a pre-existing injury? For example, 20-year back injury history, accident 3 years ago, surgery this year. So if we're talking about a Medicare beneficiary plaintiff and you are going to be settling your claim, the question is going to be, should Medicare be primary for the surgery this person is going to need because they have this, long-standing history of back pain, even though they had an accident 3 years ago? I think that in terms of addressing what the future medical component should look like and whether or not there is a cost shift of these injury-related expenses to Medicare, it would be helpful to find out, what the treating physician's opinion is. I mean, if there was no recommendation for a back surgery prior to the accident, and there is a significant change in this person's condition where the treating physician is tying this need for surgery to the trauma, then the recommendation would be that your settlement, if it's going to close out future medical and you are claiming future medical expenses, that it apportion some of the proceeds for this surgery so that you would be avoiding a cost shift of injury-related expenses to Medicare. If it's a situation where, there's a discrepancy between the total potential case value and what your settlement is actually going to be because of these causation disputes, then this is the type of situation where an apportionment of the MSA and a discussion of these issues would be appropriate when it comes to, how you should be protecting your client while considering Medicare's interests. So, I do see that we are nearing the end of our allocated time for this. If there are any other questions that do come in, and I think there are still some that are rolling in, I will address them after the webinar. But thank you very much for your time. And, as I said, the MSP Act is like a speed limit. People should make an informed decision about how they are going to respond to it. Thank you.